Bismillahirrahmanirrahim. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Assalamualaikum warahmatullahi. So today, inshallah, I'm going to talk on the defense of infancy, unsound mind, and also intoxication. The defense of infancy, unsound mind, and intoxication. Defenses of infancy, unsound mind, and intoxication. So the rationale of the defense is that if he is a child, if the accused is a child, then it is not fair to convict him for a criminal offense, and because he has no mens rea. If you look at an infant, for example, let's say a toddler age 3 years old, for example, and if let's say he steals the property of another person, so is it fair to convict him for the offense of theft, for example? Or if he push another boy, for example, is it fair to convict him for the offense of causing hurt or for the offense of criminal force? So it is not fair. It is against the principle of justice because the infant has no mens rea. So that is the rationale for the defense of infancy. Why? Because he cannot distinguish between right and wrong or between good and bad. Child may not be able to differentiate between what is wrong and what is correct, and what is good and what is bad. Generally. Okay. So there are two provisions under the penal code. There are two provisions as regards to a child or a minor. The first one is section 82 and the second one is section 83. Section 82 concerns, section 82 is applicable to children below the age of 10. Below the age of 10, yeah. When we say children, children under the penal code, criminal those who are not capable of committing any crime must be either below the age of 10 or below the age of 12. We're not talking about a 16-year-old boy, for example, or a 16-year-old girl. Yeah? We're not talking about a 16-year-old or 17-year-old, despite the fact that they are still a minor. Yeah? They have not reached the age of majority, but they are not considered as infant or child under the penal code for the purpose of committing criminal offense. Yeah. So act of child under 10 years of age, section 82 says nothing is an offense. Nothing is an offense, meaning this is also an absolute defense. Similar to the defense of accident that we have already discussed previously, defense of mistake, they are absolute defense. Similarly, the offense of an infant below the age of 10 is also an absolute defense. Nothing is an offense which is done by a child under 10 years of age, but he or she must be below the age of 10. If he is above the age of 10, for example, 14 years old, then this provision is not applicable. Nothing is an offense which is done by a child under 10 years of age. So if let's say the child is below the age of 10, so whatever he does, Even if it is murder, he will not be guilty of any offense because of section 82. Because of section 82. This is about a child below the age of 10. Child below the age of 10. Nothing is an offense which is done by a child under 10 years of age. So if let's say he is a child, what he must prove is that as a defense, it must be proved that he is below the age of 10. If he can prove that he is below the age of 10, then under the law, he's not able to commit any crime. Or you call that doli incapex, incapable of committing any crime. What if he is his maturity, his intelligence, his capability, his mind capability is similar to a 30-year-old man, for example? Doesn't really matter, because the law is clearly stated. The law is clearly states that the child below the age of 10 is not capable of committing any crime. Doesn't really matter what his mind, his ability, his capability, is not capable of committing any crime under the law. If let's say there are cases, many cases of children below the age of 10 committing crime, and the country or the government wants to stop that, then we have to amend the law, because the law is very clear. The law as it is now is very clear. Any child below the age of 10 is not able to commit any crime. What about children above the age of 10? So children above the age of 10 but below the age of 12, there is a special provision for that. It is section 83 of the Penal Code. Act of child above the age of 10 and under 12 years of age who has not attained sufficient maturity of understanding. Section 83 says, nothing is an offense, meaning that this is also an absolute defense, which is done by a child above 10 years of age and under 12, meaning a child in between the age of 10 and 12. So quite limited. His age, his or her age must be above 10. If he's below 10, then section 82 will be applicable. So he or she must be above the age of 10, but must be below the age of 12. He must be above the age of 10 and below the age of 12. So if he's 13 years old, then this provision is not applicable. So very limited range of age in between the age of 10 and 12. Who has not attained, but there is another condition. If you look at section 82, there is no condition. The only condition that must be proved, the only thing that must be proved is that the child is below the age of 10. However, under section 83, not only it must be proved that he is in between the age of 10 and 12, but there is another condition that must be proved. So what is that? Who has not attained sufficient maturity of understanding. So he must not attain sufficient maturity of understanding to judge the nature and consequence of his conduct on that occasion. So he has not attained sufficient maturity, meaning he's not able, he's not capable, he's still a child, even though he is 11 years old, but his mind has not attained, he has not attained sufficient maturity of understanding. He doesn't understand what he's doing. He doesn't know that he can't differentiate between something which is right and something which is wrong. So there is another condition. So of course, because there is this condition, therefore that child has to be evaluated by the expert kan. For example, let's say child psychologist ke, child psychiatrist ke, whatever. So the expert who can determine the maturity of that child, the ability of that child in terms of his mind, whether he has attained sufficient maturity of understanding to judge the nature and consequence of his conduct on that occasion, meaning on the day that he, or the time that he committed the crime. So that is the difference between section 82 and 83. 82, there is no condition. Once it is proved that he is below the age of 10, he's not able to commit any crime, nothing whatsoever. Whereas under section 83, this is only applicable to child in between the age of 10 and 12. Then it depends on his ability, his maturity. If he understands the nature and consequence of his act, if he is able, he has attained sufficient maturity that he understands the nature and consequence of his conduct on that occasion, then he is guilty. He's guilty of the crime. He has the necessary mens rea. If he has not attained sufficient maturity of understanding to judge the nature and consequence of his conduct on that occasion, then he is not guilty of any crime. His situation is similar to a child below the age of 10. So it depends. It depends on his maturity. So these are the two provisions, section 82 and section 83, as I've already explained. As I've already explained just now, below 10 years, absolute immunity. It doesn't matter if he is his mind is similar to a person of 30 years old, doesn't even matter. If he's below the age of 10, he's not able to commit any crime. Case here, Walters and Land. Walters and Land, the parents of a 7-year-old boy were charged for the offense of receiving stolen property. Receiving stolen property under the law, that property must be a stolen property. In order for a person to be guilty of receiving or keeping or accepting stolen property, the property must be a stolen property. So in this case, the parents, not the boy, but the parents were charged for receiving stolen property. The boy, the 7-year-old boy, had earlier brought home a tricycle. So that tricycle was the property, the property in question. The boy had earlier brought home a tricycle, and the parents, despite knowing that it was stolen, meaning it was not his boy's tricycle, it was another person's tricycle, it was not his, they kept it on their premises. So that's why they were charged for the offense of receiving stolen property. But the problem in this case was that in order for the parents to be guilty of the offense of receiving stolen property, the property must be a stolen property. So the issue that needs to be determined by the court was whether that property was a stolen property. It was found out, it was held by the court that the child, the 7-year-old boy, was not able to commit any crime. Therefore, when he took the tricycle, he did not commit the offense of theft. Because he did not commit offense of theft, that tricycle was not a stolen property. So it was not a stolen property. Because of that, the parents were found not guilty for receiving stolen property. So that was the case of Walters and Land. So this I've already explained. The age of 10 and 12 depends on his maturity, his capability of understanding. If he is able to understand the nature and consequence of his conduct on that occasion, then he's guilty. If he's not able, then he's not guilty. It depends. For this is for a child in between the age of 10 and 12. The case, Lukhiro Agradanini. In this case, it was a child in between the age of 10 and 12. Yeah? The incapacity to commit offense only arises where the child has not attained sufficient maturity. But such non-attainment must be pleaded and proved. And in the case of Abdul Sattar and another against the Crown, the accused were boys below the age of 12 years of age, above the age of 10, but below the age of 12. They opened locks on two shop premises and gone inside the shop to commit theft. In one shop, because two shops, they broke into two shops. So in one shop, they stole a bag of purse, and while in the other, there was nothing for them to steal. So the court looked at their ability. They were able to prise open locks. It was not easy to do that, and then they knew what was of valuable property that can be sold, what was not valuable that they left behind. So it is the court from their conduct, from the circumstances of the case, the court held that they had attained sufficient maturity of understanding to judge the nature and consequence of their conduct on that occasion. Therefore, the court held that they were guilty for the offense of theft, and they were not able to rely on the defense of infancy under section under the provision in India, which was similar to our section 83. So they were not able to rely on that provision, because why? Because they had attained sufficient maturity of understanding to judge the nature and consequence of their conduct on that occasion. And then another case, the case of Ullah Mahapatra against the king. In this case, an 11-year-old boy had picked up a knife. He had picked up a knife. Let's say this was a knife, and then advanced toward the victim, saying that he would cut him to bits. And then he did actually cut him. Only 11-year-old boy, but very cruel. He picked up a knife, advanced to the victim, saying that he would cut him to bits, and actually did cut the victim. The court held that the boy's entire conduct led to the one inference, which was that he knew that the cut inflicted by the knife would effectuate his intention of hurting the victim. He fully understood the nature and consequence of his conduct on that occasion, and therefore the court held that he was guilty of the crime and was not able to rely on the defense of infancy. Consequence of the conduct. What is the meaning of consequence of the conduct? The phrase of consequence of the conduct in section 83 is not defined, but it refers not so much to the likely offense which the child might have committed, but more to the natural consequences that results from the child's action. The results, for example, if you use a fire and burn a car, the car will be destroyed. For example, if you burn a person, that person will be inflamed, will be injured. For example, so it is not apparently the penal consequences. Not the penal consequences, meaning it is not what will be the punishment for that offense. Not that. That when we say consequence of the conduct, it's not that if you do that, then you will be punished with death, for example, or you will be punished with 7 years imprisonment. Not that. Not the penal consequence. The meaning of consequence of the conduct. He knows the consequence of the conduct. He understands the nature and consequence of his conduct. Not the penal consequence, but the natural consequence which flow from a voluntary act. For example, when a fire is applied to an inflammable substance, it will be burned. Or if he use an axe and cut another person, that will kill another person or cause injury to another person. So that is the meaning of understand the nature and consequence of his conduct on that occasion according to the case of Lukhini Agradanini. So that's all under the offense of infancy. So anything that you want to ask, any question on the defense of infancy, anything that you need, that you don't understand or you need me to explain further? Okay, let's continue with the defense of unsound mind. Unsound mind, gila ya, unsound mind. Unsound mind. Or insanity. Insanity. Unsound mind. Sama, maknanya gila. So this is stated, this defense is stated under section 84 of the Penal Code. Nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to the law. So if you look at this provision, nothing is an offense, meaning this is also an absolute defense. Once it is proved that he is a person of unsound mind at the moment of committing the crime, then he will not be convicted for the crime, but he will be put into a mental institution until he is safe to be released to the public. Nothing is an offense which is done by a person who, at the time of doing it, meaning at the time of committing the crime. Now, if you look here, the provision here, at the time of doing it, meaning at the moment of committing the crime, because something that you must understand, especially if you have family members who a family member who is of unsound mind, for example, or who is not mentally stable, for example, you know that certain people, they may be crazy or maybe of unsound mind, they may be insane, dia boleh jadi gila at certain time. At certain time, he may be of unsound mind. But at other time, he is well and of sound mind. Kan ada orang yang ada masa dia gila. Ada masanya dia siuman. Ada masanya dia, fikiran dia sihat, dia boleh sangat bijak pun. Tapi ada masa fikiran dia tak betul. Cakap merepek-repek. Fikir benda yang tak betul. Syak wasangka yang bukan-bukan. Ataupun dah jadi obses sangat pada sesuatu yang melampau-lampau. Ataupun berfikir yang bukan-bukan. Kan sebenarnya kalau kita fikir terlalu banyak saya fikir yang bukan-bukan, macam mana syakkan apa pasangan kita ataupun boyfriend kita ke, terlalu banyak apa kawan perempuan ke, walaupun sebenarnya dia tak ada kan, sampai melampau-lampau. Kita sentiasa syak prasangka, itu mungkin tanda-tanda kegilaan. So what is stated here, if you look at section 84, nothing is an offense which is done by a person who at the time of doing it, meaning at the time of committing the crime. If let's say he is, most of the time he is of sound mind. Most of the time he is of sound mind. The only time that he is of sound mind at the moment of committing the crime. Dia diserang penyakit gila pada masa itu. It doesn't matter. If that can be proved, then he may be able to rely on the defense under section 84. Because what is important, not that he is of unsound mind permanently. It can be temporary. It can be only at that moment. And the only thing is that he must prove that. So nothing is an offense which is done by a person who at the time of committing the crime, at the time, for example, killing another person, but at the time of using that knife and the stabbing onto the body of the victim many times, at that moment, he was of unsound mind. By reason of unsoundness of mind, he is not of sound mind. At the moment of committing the crime, he is not of unsound mind. So what is unsound mind under section 84? He is incapable of knowing. He is incapable of knowing the nature of the act. He doesn't know what is the nature of the act. He doesn't know that he is, by using that knife, stabbing that person. That is stabbing. That is harming another person. He doesn't know what is that. When he used a stick and then strike onto the head of the victim many times, he doesn't know what he's doing. He doesn't know what it is that. So that is not knowing the nature of the act. He doesn't know what he's doing. He doesn't know what is that. That is the first situation. Or he knows what he's doing. He knows that he's killing. Even by using a knife, stabbing onto the victim many times, he knows that he's killing the victim. And he intends to kill the victim. He intends to kill the victim. He knows that he's killing the victim. He intends to kill the victim, and he did kill the victim. But he doesn't know that it is either wrong or contrary to the law. This is another situation. The first situation, he doesn't know what he's doing. He doesn't know that he's killing someone. He doesn't know that he's harming the victim. The second situation, he knows that he's killing the victim. He intends to kill the victim, but he doesn't know that it is wrong. He believes that it is a noble thing to do. For example, he heard voices saying to him that child is an evil child. That that is the what we call the voice of God. For example, he heard the voice of God. For example, he believes that it is the voice of God telling him to kill that child. For example, because in that voice, the voice saying that child is an evil child. If he doesn't stop that child, then the world will be destroyed, for example. So he believes that he's doing a noble thing by killing that child. So that is also what you call another situation that a person is considered as unsound mind under section 84. Either he doesn't know what he's doing, doesn't know the nature of his act, he doesn't know that it is harming someone, it is killing someone, doesn't know that. Or he knows that he's killing someone, he even intends to kill someone, but he doesn't know that that act is either wrong or contrary to the law. So that is a person of unsound mind under the penal code for the purpose of the defense of unsound mind under section 84 of the penal code. So under the so this law, this provision, section 84 is it's actually what we call the basis of this provision was actually the law, the defense of insanity in McNaughton. The defense of insanity in England in McNaughton case. This was the first case that established the defense of insanity. And later on, when they introduced English law into India, they put this section 84. So this section 84 comes from McNaughton rule, of course, with a few differences. Yeah? And then when English law was introduced into Malaya at that time, into the federated Malay state, they what you call apply the law, the penal code of India into Malaya. Yeah? So the McNaughton's rule, every man is to be presumed sane, meaning that the presumption by the law is that every man is sane, every man is of sound mind. Semua orang ni siuman pada asasnya, pada andaian mahkamah. Every man is presumed to be sane. This is McNaughton's rule. Yeah? So this case came from the case of McNaughton. McNaughton was a person who was not, or who was of unsound mind. And then he intended to kill the Prime Minister. Because he thought that it was a good thing to do. But he mistakenly killed someone else. So then, in this case, it was found that the court found that he was of unsound mind at the moment of committing the crime. So this was the rule in McNaughton. Yeah, they call it McNaughton rules because the name of the accused was McNaughton. Yeah, every man is presumed to be sane, and to establish a defense on the ground of insanity, it must be clearly proved that at the time of committing the act, not before, not after, but at the time of committing the act, the party accused was laboring under such a defect of reason of his mind, from disease of the mind, penyakit gila, and not knowing the nature and quality of the act he was doing. He did not know the nature and quality of the act he was doing, or he didn't know it. He didn't know that he was harming someone. He was causing injury to another person, or he was killing another person, but he did not know that he was doing what was wrong. So this is McNaughton rules. In McNaughton's case, insanity is a disease of the mind which caused defect in reasoning, but not in Section 84. Section 84 is wide enough to cover disease of the mind, but it can also come from other type of insanity of unsound mind. It is not limited to disease of the mind. The malfunctioning of the mind in reasoning and understanding must be caused by disease of the mind, otherwise it will be no insanity under McNaughton. And this is under McNaughton, but not under Malaysia. In Malaysia, Section 1984, no, Section 94. Section 84 is wide enough to cover the malfunctioning of the mind or disease of what we call the unsoundness of mind because of other things, not limited to disease of the mind. The disease may be physical or functional psychosis in origin. This was held in the case of R against Kemp. So Section 84 of the Penal Code, Section 84 is not a medical concept, but a legal concept. And it is a legal test, not a medical test. When we say, under Section 84, when we say unsoundness of mind, a person of unsound mind, unsoundness of mind, we refer to unsoundness of mind or insanity under the law. Insanity under the law, legal insanity, not a medical insanity. This was held the case of Muhammad Mas'ud Rana against Mofizuddin. So a person may be medically unsound, but he may be legally sound. For example, let's say a person may be legally unsound, but he may be legally sound. For example, a person is suffering from some sort of disease, mental disease. Dia ni tak berapa siuman sangat. It's not. He requires medication, for example. He needs to go to the hospital and take medication. Every 3 months, he has to go to replenish his medication. He must get back all the medications. After 3 months, he has finished off all the medication. He must take that. He must take that for his whole life, for example, because of his mental disease. But let's say he kills someone. At the moment of killing that person, he knows that what he's doing. He knows that it is wrong. But he kills that person because he hates that person. He knows that it is wrong. So if that is the situation, he may be medically insane, but legally he is sane. He knows that what he's doing. He knows that he's killing someone, and he knows that it is wrong. If that is the case, even though he may be medically unsound, but he is legally sound, he may still be convicted for the offense of murder and may not be able to rely on the defense of insanity under Section 84. So that is what is meant by it is not a medical concept. It is not a medical insanity, but it is a legal insanity. This was held the case of Muhammad Mas'ud Rana Mofizuddin against the public prosecutor. The law is concerned with the question of the accused's responsibility for his actions. The concern is with the cognitive or knowingness of the accused person. The nature and extent of the unsoundness of mind must impair the cognitive faculties so as to make the offender incapable of knowing the nature of his act or what he is doing is or is wrong or contrary to the law. This was held in the case of John, anak kepada Nyumbe, against the public prosecutor. Even if the legal and medical concept may overlap, most of the time they overlap actually. Most of the time, a person who is medically unsound is also legally unsound. Most of the time. Ya, orang yang gila yang dah terlupa kat tengah jalan tu, ya, cakap epek-epek, tiba-tiba nak marah orang tu pasal kan. Terlalu depan dia, tiba-tiba dia nak marah, tiba-tiba dia nak serang kita ke. So generally, he is medically insane. If he's brought to the hospital, the doctor may prescribe certain drugs for him, certain medication for him, because he is of unsound mind and that he needs to be calmed down, to take drugs to make him can control a little bit control to his behavior, perhaps. So that is he is medically unsound. And if he causes injury to someone, he may also be able to rely on the defense under Section 84 because he is also legally unsound. So that is overlap. He is actually legally unsound and medically unsound. So most of the time they overlap, even though there are exceptions to this. There are persons who are considered as medically unsound but legally sound, and there are also persons who may be medically medically sound but legally unsound. Example, an uncontrollable impulse to kill would be considered medical insanity because he needs some sort of treatment. He needs some sort of evaluation and treatment, for example. But it may not be disease. It may not be considered as disease of the mind under Magnetic rules or unsoundness of mind under Section 84. So he may be medically insane because he has an uncontrollable impulse to kill, but he may not be legally insane. On the other hand, a person defective with intelligence or suffering from epilepsy may fall within the scope of Section 84, though he is not medically insane. Orang yang a person who is mentally retarded, for example. A person who is mentally retarded. Orang yang terencat akal, for example. So he may not be legally insane. Under the law, he is not legally insane. But if he is not able to understand the nature and consequence of his conduct on that occasion, then he is legally unsound under the law. So it's not limited to what we call unsoundness of mind, but if his intelligence has not reached certain level, then he's also considered as a person of unsound mind under Section 84. Unsound mind under Section 84 is wider than Magnotten rules, as it does not matter whether the defect in the reasoning was due to degeneration of the brain or some other cause. Unsoundness of mind includes not only disease of mind causing a defect of reason, but also mental deficiencies which may not result from disease of the mind. In Kong Nan Siu and Lim Siu Hong, it was stated that for the purpose of legal proceedings, the words unsoundness of mind or insanity or mental illness will be deemed to have the same meaning. So the burden of proof. The burden of proof, this is the burden of proof to prove that he is of unsound mind. And this is not the burden of proving the crime. But the burden of proof that of the defense that he is of unsound mind. Who should prove that? Definitely lah kan. The person who alleged that he is of unsound mind must prove it. That is the accused lah. The accused must prove that he is of unsound mind. This is stated under Section 105 of the Evidence Act 1950 and the case of Kofri Mustafa against the public prosecutor. The standard of proving, this is the standard of proving that he is of unsound mind, not the standard of proving that he is guilty of the crime, but the standard of proving that he says that, okay, at the moment of committing that crime, I'm not of sound mind. I am insane. I did not know what I was doing. So he claimed that. If he claimed that, he must prove that. So, what is the standard of the proof, of the burden of proof? The standard of the burden of proof is that it is on the balance of probability, meaning that it is higher probable that it is higher probability that he was of unsound mind, then the court may accept that allegation. If it is lower probability that he is of unsound mind, then the court may reject that defense. This is the defense, and not the case. The criminal act that must be proved that by the prosecution is still beyond reasonable doubt because it is a criminal offense. This is the burden of proof that we are discussing now, is the burden of proof that to prove that he is of unsound mind. So medical opinion usually tendered as proof of unsound mind. Medical opinion, because in order to determine whether he is of unsound mind, whether he is of sound mind, so that must the court has to determine that. But how to determine that? By calling for medical opinion, by calling the medical expert, the psychiatrist, for example, the medical officer, for example, that who has the medical officer who has examined the accused, so that they may be called, he or they may be called in order to determine the mental the mental capability of the accused at the moment of committing the crime. But evidence of the circumstances after the crimes or subsequent conduct of the accused would be relevant in determining whether the accused is of unsound mind at the time of committing the crime. So, because what is important to be determined by the court is the mental attitude, mental situation, the mental capability or mental state of the victim at the moment of committing a crime. That is what is important. But how to determine that? So in order to determine that, sometimes the court will look at what happened before that, whether he had any previous what you call medical insanity history. For example, he used to go to the hospital every month for his medication, because he has history of mental problem, for example. All this will be taken into consideration. Or after the act, what he did after the act. If let's say he was trying to destroy or conceal the evidence after the committing the crime, that may show that he knew that he was doing what was wrong. This was held in the case of Muhammad Mas'ud Rana, Muhammad Mofizuddin against the public prosecutor. He will not be able to use unsoundness of mind as a defense if the act itself has shown a degree of guilt and an effort to avoid detection. If he tried, he showed that he knew that it was wrong, he felt guilty, he tried to avoid detection. All these showed that he had intention. Oh no, he was he did understand the nature and consequence of his conduct, and he did know that he was doing something which was wrong. The defense of unsoundness of mind need to be established at the earliest moment, which is at the prosecution stage, in order to avoid any allegation of an afterthought. It's better if they make the allegation that he's going to, that the defense counsel inform in the very early stage, that he informs to use unsoundness of mind as his defense, not after the whole case of prosecution has already finished. The prosecution has already finished with all his evidence, and then only he make an allegation that the victim was of unsound, the victim, like the accused was of unsound mind, because that may make the court thought that it was an afterthought. The case of Pepi against Muhammad Suhaimi Abdul Aziz, the accused was charged for the murder of his wife under Section 302 of the Penal Code. Post-mortem revealed that the deceased had suffered 36 stab wounds. The wife was stabbed 26 times, at least 26 times by the husband. The accused claimed that he was feeling very depressed and that his mind was full of negative thoughts. He heard voices talking to him, directing him to do something to his wife. It was like taking over his mind and taking over control of him. He remembered going to the bathroom and breaking down the door, and later he didn't know what happened. He only remembered going out of the house and getting into his car. And then, of course, the court called the secretaries, the expert opinion, and take all the consideration what was in his mind. And then the court found that he was of unsound mind at the moment of killing his wife. He did not know what he was doing. He did not know he was doing what was wrong. Therefore, the court allowed him the defense of insanity or unsound mind under Section 84. Okay, we take a 10 minutes break. We continue at 9. It's now 9 o'clock. We continue at 9-10 minutes, insyaAllah. Jadi, ambil rehat dulu sekejap untuk bagi tenangkan fikirannya. Okay. Okay, let's continue with the defense of unsound mind under section 84. In order to invoke the defense under section 84, the accused must establish at the time of doing the act he was incapable of knowing the nature of the act or incapable of knowing that he was doing what was either wrong or contrary to law. So these are clearly stated, these things are clearly stated under section 84 of the Penal Code. So time of the doing of the act. The accused must be of unsound mind at the moment of commission of the offense, regardless of whether it is permanent, whether the unsoundness of mind, it can be permanent or it can be temporary, doesn't matter. What is important is that at the moment of committing the crime, he must be of unsound mind. This was held in the case of Kofri Mustafa against the public prosecutor. It is not relevant if he was suffering from the alleged condition before or after the act. The fact that he was of unsound mind, the fact that he was of sound mind when he was examined does not mean that he is of sound mind at the time of the offense. This was held in the case of Padala Suryana Rayana. So what is important is not his state of mind at the current moment, but his state of mind at the moment of committing the crime. If let's say he was of unsound mind at the time of committing the crime, even if later on when he was examined by the medical officer, he was found to be of sound mind, doesn't matter. Because what is important is his state of mind at the moment of committing the crime. So that is what is important. But of course, the examination done by the expert, by the medical expert, by the secretaries may help the court in deciding the state of mind of the accused at the moment of committing the crime. So this is incapable of knowing the nature of the act. So these are the two limbs I already explained. So the nature of the act, the accused may still claim the defense under section 84 even if he knows the nature of the act, if at the time of doing it, by reason of unsoundness of mind, he does not know that the act is either wrong or contrary to law. So if either he doesn't know the nature of the act, or even if he knows the nature of the act, but he doesn't know that it is wrong or contrary to law, then he may still be able to rely on the defense under section 84. So what is wrong? Definition of wrong. Wrong cannot be taken to mean contrary to law. Why? Because if, let's say, wrong means contrary to the law, then it will be redundant. It will be repeating if you do section 84. If wrong means contrary to law, it will become redundant. And therefore, wrong means morally wrong. This was held in the case of Sivraj Singh against the state of Madhya Pradesh. Why? If you look at section 84, you look at section 84. So you look at section 84. All that he's doing is either wrong or contrary to the law. So the meaning of wrong here. If wrong here means contrary to law, then this provision will be read as all that he's doing what is either contrary to the law or contrary to the law. So it will be redundant. It will be repeating. So because of that, wrong here does not mean contrary to the law, because the word contrary to law has already been used here under section 84. That's why wrong under what you call section 84 means morally wrong, according to Shivraj Singh against the state of Madhya Pradesh, not contrary to the law. because if it is contrary to the law, then it will be redundant, it will be repeating, because the word after that is contrary to the law. So whether to read this conjunctive or disjunctive, conjunctive or disjunctive approach. Conjunctive view wrong here means morally wrong. Morally wrong, and section 84 requires the accused to show that his or her unsoundness of mind rendered him or her incapable of knowing that the act is wrong and that it was contrary to the law. So this is conjunctive, meaning that the court consider both wrong and also contrary to the law. Both the court consider together. If the court consider together, we call this conjunctive view. Another view, disjunctive view, meaning the court consider either it is wrong or the court consider contrary to law, either one. If the court consider either one, we call this disjunctive view. Yeah? There are many cases, what they call accepting the conjunctive view, and there are also many cases accepting the disjunctive view. Let's look at the cases. Yeah. In Jeron Ali against Emperor, conjunctive view was taken. Conjunctive meaning the court considered both. When the accused was found incapable of knowing that what he was doing was either wrong or contrary to law, by reason of unsoundness of mind when he killed. So the court considered both wrong or contrary to the law. However, in Ashruddin Ahmed against the king, the court take disjunctive view. The court only consider one. Yeah? Disjunctive view was taken, and the appellant was held incapable of knowing that his act was wrong. His act was wrong, but the court did not consider contrary to the law. So this is just disjunctive. In Jeron Ali, the court considered both wrong or contrary to law. So this is conjunctive view. In the Malaysian case of Azro against the public prosecutor, the court took a conjunctive view when it stated that Section 84 required that there must be unsoundness of mind and that it must lead to one or two consequences. Either that the accused is incapable of knowing the nature of the act, or that he was incapable of knowing that what he was doing was either wrong or contrary to law. You look here, the word wrong or contrary to law, both the court considers. So this is conjunctive view. In the case of Jusuf against public prosecutor, the court has taken this disjunctive view, where the court did not mention the other element, which is contrary to the law. The court only considered a wrong, but the court did not consider contrary to the law. So this is disjunctive view. In this case, the court held that if the appellant was of unsound mind and as a result did not know that he was doing what was wrong, Section 84 could protect him. The court only consider wrong. He knows that he did not know that he was doing what was wrong, but the court did not consider contrary to the law. So this was a disjunctive view. Disposal, what will happen? If let's say the accused has been found not guilty because of unsoundness of mind, what will happen to him? This is disposal of case on the ground of unsoundness of mind. When the accused is found not guilty by reason of unsoundness of mind under Section 84 of the Penal Code, Section 347, and also Section 348 of the Criminal Procedure Code, and this is not of the Penal Code. This is of Criminal Procedure Code. The procedure of the criminal cases can be found in the Criminal Procedure Code. The offense can be found under the Penal Code. The procedure can be found under the Criminal Procedure Code. The accused will be kept in safe custody at the pleasure of the ruler of the state, usually in a mental hospital. So if he is found not guilty because of unsoundness of mind, then he will not be released to the public. It's not similar to the other defenses. He will not be released to the public, but instead he will be put in a safe custody at the pleasure of the ruler of the state. So it depends on the state. If it is what we call Selangor, then the Sultan of Selangor. So he will be put in the, usually he will be put in a mental hospital. So he will remain there until he is safe to be released to the public. This was held the case of public prosecutor against Kahar Solihin. So that's all on the defense of unsoundness of mind or insanity. So now let's move on to another defense. This is the defense of intoxication. The defense of intoxication. The general rule is stated under section 85, subsection 1. The general rule is that intoxication shall not constitute a defense to any criminal liability. So the general rule, intoxication is not a defense. That is the general rule. You cannot use intoxication as a defense. So generally, intoxication is not a defense. You cannot simply drink intoxicated drink and becomes and later on commits a crime. So and use that your state of mind as a defense. That is not allowed. However, there are exceptions to this. There are situations whereby intoxication can be accepted as a defense. So intoxication as a defense is rather an exception. It is an exception rather than a general rule. In contrast with, let's say, insanity. Insanity is a defense. However, intoxication is not a defense. There are situations whereby intoxication can be accepted as a defense. So it's rather an exception. It is an exception rather than a general rule. In contrast with unsoundness of mind, for example, if the general rule is that unsoundness of mind can be accepted as a defense. So the situations whereby intoxication can be accepted as a defense are clearly stated under section 85, subsection 2 of the Penal Code. Intoxication can only be a defense when, number one, at the time of the act or commission complete of, the accused did not know such act or omission was wrong or did not know what he was doing. And the state of intoxication was caused without his consent by the malicious or negligent act of another person. Or the second situation, the person charged was by reason of intoxication insane, temporary or otherwise at the time of such act or omission. So an intoxication can only be accepted as a defense if at the time of the commission of the criminal act, he did not know what he was doing. He did not know he was doing what was wrong, or he did not know what he was doing, similar to a person of unsound mind. And the state of intoxication, he was intoxicated without his consent, meaning someone spiked his drink, someone put drugs into his food, into his drink, and that thing must be done with malicious intent, dengan niat jahat, or negligent act of another person. Malicious or negligent act of another person. Or the second situation, he was intoxicated at the time of committing the act. He was intoxicated. He did not know what he was doing was wrong or contrary to the law. He did not know what he was doing was wrong, or he did not know the nature of his act, and he did that because of he was intoxicated, and as a result of intoxication, he became insane. And that insanity can be temporary or otherwise. So this is the second situation. At the time of committing the act, he became insane. He became insane, had either temporary or otherwise, because of the intoxication, because of the intoxicated drink or intoxicated drugs. So these are the two situations. First situation, it was given to him without his consent by the malicious or negligent act of another person, and as a result of that, he became intoxicated, and he did not know what he was doing, and then he commits a crime. The second situation, he did it perhaps on his own accord, but he became insane. Because of that intoxication, he became intoxicated and he became insane as a result of that intoxication. That insanity can be temporary or otherwise. So these are the two situations whereby a person can rely on the defense of intoxication. So under section 85, subsection 2, the elements of intoxication are, number 1, he being in the state of intoxication. Number 2, the state of intoxication was caused without his consent by the malicious or negligent act of another person, or, so this is all, or the state of intoxication rendered him insane. He became insane, dia jadi gila. And this is applied to both situations, and he did not know that his act or mission was wrong, or he did not know what he was doing because of that intoxication. So only if he fulfills all these requirements, and then only he may be able to rely on the defense of intoxication. Once the elements in section 85, subsection 2 has been established, section 86 will be applied. So what is section 86? If the intoxication is involuntary and without his consent due to the malicious and negligent act of another person, the accused will be acquitted. So because if you look at section 85 subsection 2 just now, there are two situations. Number 1, without his consent by the malicious or negligent act of another person. So if this is a situation, then he will be acquitted. The second situation is he becomes insane. The state of intoxication rendered him insane. So if it is a second situation, then irrespective of the intoxication was self-induced or involuntary, section 347 and section 348 of the Criminal Procedure Code will be applied. This is similar to a person of unsound mind. He will be treated similar with a person of unsound mind, and the accused shall be ordered to be kept in the safe custody at the pleasure of the ruler of the state, usually in a mental institution. Self-intoxication, the accused is said to be in the state of intoxication, thus he has no intention to commit offense. This was held in the case of Tan Hong Song against R. The influence of alcohol would impair the criminal liability of forming the intention or knowledge. The effects of intoxication can be momentary or transient or long-lasting. This was held in the case of Chan Sui Fong against a public prosecutor. He may become insane or he may become intoxicated either temporarily or permanently. Scientific evidence is important to support that the accused was under intoxication, but its absence is not fatal. This was held in the case of Francis and Tony Sami against the public prosecutor. The court will still look at the conduct of the accused before and after the commission of the offense. This was held in the case of public prosecutor against Muhammad Nur Riza Mattaha. Malicious or negligent act of another, if the accused voluntarily gets into the state of intoxication, he would be responsible for his actions. Voluntary or self-induced intoxication does not provide protection from criminal liability. In the case of public prosecutor against Tan Chi Ken, the defense of intoxication under section 85, subsection 2 was held inapplicable, as the accused had voluntarily swallowed the pills which had allegedly caused his intoxication. If you look at the first situation, there are two situations under section 86, under section 85, subsection 2. The first situation, it was not with his consent. If it is under the first situation, then if let's say he takes that intoxicated drink or intoxicated drug purposely or voluntarily, then he may not be able to rely on the defense of intoxication under the first limb of section 85, subsection 2. This can be seen in the case of public prosecutor against Tan Chi Ken, because in this case, he becomes intoxicated by swallowing the pills. that he did voluntarily. It was not done. It was not done by another person maliciously as required under Section 85, subsection 2, under Lim 1. So he was not allowed the defense. And then the second situation, intoxication causing insanity. Intoxication is also a defense under Section 85, subsection 2, the second limb, where it causes a state of insanity. The accused must establish that at the time of the act or omission, he was, by reason of intoxication, insane, either temporary or permanently. This was held in the case of public prosecutor against Tan Chi Ken. The case of public prosecutor against Kumaran Kunciraman. This is under the second limb of Section 85, subsection 2. In this case, public prosecutor against Kumaran Kunciraman, in this case, the accused was charged for the murder of his daughter. So he killed his own daughter. And he did that in front of his wife and son, in front of the mother of his daughter, and also in front of the brother of the daughter. The act took place when the accused was at home drinking alcohol. So the accused was at home, he was drinking, he was enjoying alcohol, he was drinking alcohol, and then he quarreled with the deceased. He quarreled with his daughter. He had an argument with his daughter, and then the daughter went into the family car. Okay, dia merajuk lah ya. She went into the family car, and the accused later on asked his son to bring him some petrol. The reason, according to him, was to put it into his motorcycle, to fuel his motorbike. So the son brought the the fuel, and then he, instead of putting it into his motorcycle, he tossed the petrol can inside the car where his daughter was in, and then he lit the fire in the car, and the daughter was burned alive. She died later due to the incident, due to being burned alive by her own father. The accused contended that he was drunk and that he intended to burn red ants infesting the garage. He told the court, and was based on the evidence, based on the evidence of the psychiatrist, he intended to burn red ants infesting the garage. It was not, he did not intend to kill the daughter, but his intention was to burn the red ants infesting the garage. The accused was ordered, then the court found that he became insane as a result of that intoxication, because as a result of drinking the intoxicated drink. And the accused was found not guilty because of intoxication, and he was kept in the safe custody at the pleasure of the Sultan because of this intoxication and because of the intoxication that caused him to be insane. This was held in case of public prosecutor against Kumaran Kunciraman. So no knowledge that the act was wrong or what he was doing. The accused must prove that by reason of his intoxication or his insanity at the time of the act or omission. This was held in the case of Chan Kui Fong against the public prosecutor, that he did not know that such act or omission was wrong, or he did not know what he was doing, similar to a person of unsound mind. The state of mind of the person of intoxicated, who can rely on the defense under Section 85, is similar to a person of unsound mind. He did not know what he was doing, or he did not know he was doing what was wrong. The phrase did not know that such act or omission was wrong, or he did not know what he was doing is undetermined, whether to read conjunctively or disjunctively. In Aladdin against the public prosecutor, the accused consumed too much alcohol at a wedding feast. He quarreled with the deceased and slashed him to death. The court held that the accused knew what he was doing. Because he knew what he was doing, he was found, he was not able to rely on the defense under Section 86, Section 85. So, but in this case, the court considered what they call, he knew what he was doing. The court only considered one. He knew what he was doing. Therefore, it was a disjunctive view. Yeah? The court read disjunctively. The word wrong in Section 85 also is still undetermined, whether to mean a moral wrong or a wrong according to the law. However, it is suggested that wrong in the provision should mean wrong contrary to the law, as the extent to which law will enforce a moral per se is given to doubt. The state of drunkenness may be relevant to determine whether the intention has been formed. Drunkenness which does not prevent the accused from forming the necessary intent, but merely inflames his passion and wraps his moral judgment, is not a defense. Section 85 only extends protection where the alleged state of intoxication is caused without his consent. So this is the first part. The first part must be without his consent. The second part maybe can be with his consent, but he must become insane. This is Kumaran Kunciraman. The first part of Section 85, Subsection 2, it must be without his consent. And that without consent must be with the malicious or negligent act of another person. Someone spiked his drink, where the intoxication induced insanity, temporary or otherwise. Public prosecutor against Satya Silan, anak lelaki Periasamy, and another. It does not cover any state of intoxication such as voluntary or self-induced intoxication, as in public prosecutor against Kumaran Kunciraman, involving the deliberate taking of intoxicants. This ought to be considered as an aggravating factor. This was held in the case of public prosecutor against Satya Silan, anak lelaki Periasamy. Intoxication caused without his consent, but by the non-malicious or non-negligent act of another person is also not acceptable. Even if it is without his consent, but if there is no malicious intent or negligent act, he may still not be able to rely on the defense of intoxication. For example, let's say the accused is given without his knowledge and intoxicants. He did not intend, he did not want to drink that drugs, he did not want to drink that the intoxicated drink, but someone put drugs into his drink, someone spiked his drink, or someone gave him alcohol in his drink, or give him to drink alcohol without his knowledge, and that leads to his drunkenness. But let's say it is in a birthday party. If it is a birthday party, or by a mistake, and then he becomes intoxicated and do a wrongful act or do a criminal act, he may not be able to rely on the defense under Section 85, Subsection 2, Lim 1. Because under Lim 1, it must be, not only it must be without his consent, as in this example, but it must also be with, it must be done with malicious intent, dengan niat buruk. If you look at this example, it is not with malicious intent, it is in a birthday party to make him happy, then that provision, the first part of Section 85, Subsection 2, will also not be applicable. Section 86, Subsection 2 of the Penal Code, even though it is not covered under Section 85, Section 86, Subsection 2 allows the court to take into account whether during the state of intoxication, the accused had formed an intention, specific or otherwise, and in the absence of that, the accused shall not be guilty. Where the effect of intoxication is that the accused did not form the requisite intention, Section 86, subsection 2 is a complete defense. Intoxication man may be capable of forming a specific intent, but may not do so in the particular alleged offense due to intoxication because he was intoxicated. Therefore, he did not have the specific intent. If he did not have the specific intent, then it may not be safe for the court to convict him for the alleged offense. In the case of Sia Eng Ju against the public against Regina, the accused was a police supervisee. Police supervisee meaning he was under the police supervision. He must report to the police, and he must be inside his house after 7 p.m. and he cannot go out of his house before 5 a.m. So in between the 7 and 5 a.m., 7 p.m. and 5 a.m., he must be at home. That was the regulation. That was the rules imposed on him. He was convicted for contravening the restriction. His defense was that he was in a bar in the afternoon and intended to leave at 6 p.m. because he needed to be home at 7. But he was too drunk and he fell asleep. And because of that, he returned home only at 9:30 p.m. after the restriction hours. Yeah? He must be at home by 7, but he came home at 9:30. And therefore, he was duly arrested. It was contended that the mens rea was part of the offense. However, the court rejected it and held that there was an absolute prohibition against being outdoor, and mens rea was not a constituent part of the offense. Therefore, even though he did not realize, because he was too intoxicated, but the court held that this offense was an absolute prohibition. It was a strict liability offense, whereby the mens rea was not necessary. In Subha Singh against the public prosecutor, the accused was convicted of murder. He pleaded the defense of intoxication. The court reduced the conviction to culpable homicide not amounting to murder, as his mind was so obscured by the drink that the accused is incapable of forming that intent. Section 86, subsection 2 is confined to offences. Section 86, subsection 2 is confined to offences where the definition requires specific mental condition of intention, but not the mental condition of nose. This was held in the case of Jumaat bin Samad against the public prosecutor. The exemption provided by Section 86, subsection 2 cannot extend to offences where the mental condition of the nose is an element of the offence. In public prosecutor against Kenneth Fook Moon Lee, the accused claimed that he was in the state of intoxication when he did the act of killing, when he killed. It was held that the court need to determine whether the accused had the requisite specific intent in the light of his intoxication. Section 300, paragraph C of the Penal Code requires intention, and that intention was not there as he was intoxicated. So in this case, even though he was not able to rely on the defense of intoxication, but because he was intoxicated, he did not have the required mens rea under Section 300. The intention to cause the bodily injury which is sufficient in the ordinary course of nature to cause death. It was not there because he was intoxicated. His mind was absent. Therefore, he was found, it was not safe to convict him for the offense of murder. The accused may only apply Section 86, subsection 2 if there was no preceding fault and he did not realize that he would get into a state of automatism. If, let's say, he had the intention to commit the crime and then he took the drink, he takes the drink to give him the false or Dutch courage, they call that, because if you want to kill someone or harm someone, then you'll be scared, and then the accused will be scared, the accused will have some hesitation. So in order to have the courage to do so, he take intoxicated drink. So this is called false or Dutch courage. If he did that, then he cannot use that as a defense. This was held in the case of AG for the Northern Ireland against Gallagher In this case, the court held that if a man, while sane and sober, forms an intention to kill, meaning that he had the intention to kill before taking the intoxicated drink, and then after that, having that thought, after having that intention, then he took the intoxicated drink to give him the Dutch courage, to give him the courage to kill. He cannot rely on this self-induced drunkenness as a defense to a charge of murder, not even in reducing it to the offense of manslaughter. We call the offense of manslaughter in Malaysia as culpable homicide not amounting to murder. The wickedness of his mind before he gets drunk is enough to condemn him, coupled with the act which he intended to do and did so. That's all under the defense of intoxication. So, and that's all for today. If you have any question, you may ask. Time's already up. You have another class after this. So we stop now. If you have any question, you may ask during the tutorial, inshallah. So that's all for today. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Thank you, Doctor.
Thank you, Doctor. Thank you, Doctor.